All right, welcome to the last video for business law class for the spring of 2020. Again, I want to tell you how much I appreciate all of you and your flexibility. This was strange and different for all of us. I would much prefer to be there in class and in person, and that way I can answer any questions, those kind of things. But again, remember, feel free to email me any questions you may have. Going forward. All right, so we're at that point in time in our class where I want to kind of give you some reminders. I know you've already seen this slide from the other video regarding secure transactions, but I still wanted to make sure you saw it again. Extra credit papers and the ethics papers are due before Thursday at 6:30 p.m. I know originally I kind of said before final, but since we may be moving that final around, I want them in before Thursday 6:30 so I can kind of get them graded and get your grades posted. I will do my best to have a study guide out by the end of this weekend. And I also want to remind you all that evaluations, I got an email that evaluations are out there. Please give an evaluation. I do read them, and I do like constructive criticism, and therefore I encourage you to do those evaluations. Right. So we're now into bankruptcy law, right? We've talked about generally how courts work, so you've learned about that. We've talked about different types of businesses. We've talked about things to avoid, such as torts actions. We've talked about contracts and how those work, whether it be contracts under the common law or contracts under consumer goods. So now we move to a situation, well, business didn't go well, and you may have to declare bankruptcy. This will also apply to you as individuals. We'll talk about Chapter 13 as we kind of go through it all. All right, so bankruptcy is where we're at now. Kind of an overview of the bankruptcy code. There are 8 chapters. All of them except for Chapter 12 are an odd number, which is, don't ask why the legislature decided to do it that way, but they did. 1, 3, and 5 are generally the administrative rules that apply to all of the other chapters. 7, 9, 11, 12, and 13 are the substantive chapters. Again, the only ones we're really going to be going over are 7, 11, and 13. Now, I do want you to understand what the basic goals of the U.S. Bankruptcy Code are. 1, rehabilitation. That really is what ultimately we try to steer things, or I shouldn't say we, the federal tax courts try to steer everything towards chapters 11, 13 to rehabilitate people. And then if we can't get them done, right, then we're going to move to Chapter 7, which was the liquidation. So chapters 11 and 13, remember 11 is for businesses rehabilitation, 13 is for consumers rehabilitation. Right, so in rehabilitation, it's usually done by creditors agree to either less than an actual debt or any future earnings type of a situation. Right, instead of paying an entire dollar, they are going to take 75 cents of a dollar, understanding some is better than nothing. It allows time, space, and sometimes a reduction from the debt. By the time and space, we're talking about sometimes creditors can be all over you as a business or an individual, and by declaring bankruptcy and the process that it takes, they all have to step back and they can't harass you, those kind of things. So it gives you that time and space that you may need to figure out how I can pay these back over a time period. Chapter 7 is liquidation, right? That's basically where what are all your assets? What are all your debts? And let's figure out how we're going to pay those off depending on, remember that secure transactions was who's first in time, and if you are one, the senior person versus a junior person in line, an interest holder, then you're going to get paid first depending on what goes on. All right. We're going to talk about kind of how that all works, who gets paid first and why they get paid first under these different chapters. Creditors are not entitled to any future earnings, right? In chapters 11 and 13, it could be here's I'm agreeing to pay you X amount of dollars for the next 3 years or 5 years as part of paying you back this debt. Whereas liquidation, we're just selling everything off, and whatever money's there is what we're going to use to pay off any of the folks that have an interest. All right, primary goals again, preserve the debtor's property. By that, what we're trying to do in the liquidation, we're going to sell it all off, but even then we're still trying to hopefully once we've sold everything off, we paid off all those folks who are entitled to be paid off, maybe there's still something left over for you. Not always, but we're trying to do everything we can to preserve a debtor's property. We're certainly trying to do so when it comes to chapters 11 and 13. We want to divide the debtor's assets fairly between the debtors and the creditors. We want to make sure to a degree, remember, if you've got a secured interest versus a non-secured interest, you may or may not get paid. But if you have a secured interest, we're going to try to get you paid at the same rate as all others that have secured interests as well. Divide debtors' assets fairly between the different levels of creditors. All right, let's talk about Chapter 7, liquidation first. What happens generally is a filing of a petition. Now that can be you deciding I can't go forward anymore, and so to get rid of all the hassle that's going on in life, you file a petition for bankruptcy. It happens all the time, in which people, to avoid maybe losing a house or whatever, they're going to file that bankruptcy because that stops the process, foreclosure process, that stops any harassment that's going on from occurring until the bankruptcy court makes a final decision. But it can be voluntarily filed by the debtor or the entity going bankrupt. For individuals, they must have met with a credit counselor within 180 days because that credit counselor is going to try to steer them either into Chapter 13 to try to see if they can be rehabilitated. And so they have to have done that for 180 days, that process first, before they can do a Chapter 7. It doesn't mean that if you've tried Chapter 13 and it's not working out, you can't turn around and turn it into a Chapter 7 bankruptcy. For individuals, income less median income of their estates or can't afford to pay back $7,475, it's over a 5-year period of time. It's really a low dollar amount on purpose because, again, we're going to steer you towards liquidation if we can get all that done. Petitions have to include lists of your creditors, a schedule of any assets and liabilities that you have, any claims of exemptions. You may have a house, or you may have something that a truck that you use for the truck, but it's also a personal truck, right? Whatever it may be. Your income and your home expenses, if it's an individual liquidation, and then statement of any financial affairs. It can also be involuntarily filed by the creditors, right? There's the petitioner, the person wanting to go bankrupt can file it voluntarily, or it can be involuntarily created by folks. If a debtor owes at least $15,000 in an unsecured claims, right, then it can be done by those folks who have that security interest. Debtor has at least 12 creditors, then 3 of them have to sign on. If it's less than 12, then any one of those 11 creditors can force an involuntary bankruptcy. The alleged custodian, or sometimes in the law world is called a receiver, then gets appointed, or debtor is not paying debts that are past due. All right, an order for relief is an official acknowledgement that a debtor is under the jurisdiction of the bankruptcy court. I receive these all the time in civil cases because, for example, maybe there's some collection action going on, and whether it's a business or an individual which a creditor is trying to collect from, and I get a letter that says, hey, bankruptcy court is officially involved, and that stays. The word stay is what's used, which means everything ceases to happen as far as anything other than the bankruptcy court. If you're a creditor, you have to stop hassling. You can't continue to ask them for money or anything of that nature. If you do, you could be in violation of the federal law and can have consequences for doing so. That's called an order of relief. All right. When that happens under Chapter 7, a trustee is then appointed. They oversee the administration of that bankruptcy. They're the ones that are responsible to make sure all assets are protected and all the assets around, determine who all of the creditors are, what type of creditors they may be, whether it's a secured creditor or an unsecured creditor, those kind of things. They're eventually going to be responsible for, once they've got all those collections and they get the approval of the bankruptcy court, to then disperse all those monies to those creditors. A proof of claim is a form stating the name of an unsecured creditor and the amount of claim against the debtor. In other words, if I find out somebody is declaring bankruptcy, they may not have indicated that I, in fact, am owed money. So I may do a proof of claim and have to demonstrate to the trustee, these are the debts owed to me by this particular person filing for bankruptcy. If it's a secured one, remember there's already going to be proof of it somewhere in the Secretary of State's office or whatever. Again, automatic stay, I talked about that. It's a petition filed. Any attempt to collect on the debt incurred before petition is filed ceases. Everything stops at that point in time. That's that automatic stay. Once you file bankruptcy, it is an automatic stay. But we'll get that order for relief, that notice sometimes that says, hey, you need to stop what you're doing as well. For a bankruptcy estate, that is essentially all assets of that estate. So the trustee is going to determine what are all the assets. That becomes into what's called a bankruptcy estate. That's all the money and pools are going to be used to pay off those folks who claim some sort of debt owed to them. Exempt property, a code permits some individuals to keep some property for themselves to live on. For example, your main home, maybe your main cars, plus some limited income or amount of money to pay for certain bills. Those are what are considered exempt properties. Voidable preferences, a trustee can avoid payments or liens made by a debtor to a creditor just before a bankruptcy filing. This does occur. Say, for example, I have a loan with my father-in-law. I really want to make sure he gets paid, but it's unsecured loan versus I have all these secured interests out there, maybe trucks or whatever it may be that I need to get paid off. Those loans on those need to get paid off. And so I take whatever money I have and I pay off my father-in-law. The bankruptcy court, that trustee, can come back and say, look, you father-in-law, give me the money back. We're going to put that back into the bankruptcy estate and use that to pay off some of the secured interests, folks. Fraudulent transfers, again, kind of my paying off my father-in-law could have been perfectly legal to do so, but there may be situations where it's a fraudulent transfer where it really wasn't, right? Maybe I move a second home or third home to my brother-in-law for really cheap, right? Knowing that he's just going to give it back to me. Clearly, fraudulent transfers within a year of the petition can in fact be made part of the bankruptcy estate, and the trustee can void out any of those transactions, take that property and use that to pay off the debtors. Those are called fraudulent transfers. All right, payment of claims. There is an order when it comes to Chapter 7, and it applies the same in some of the other chapters, although in chapters 11 and 13 there's a lot more flexibility for you to decide how. In fact, you'll see that there's a plan that's produced by the bankruptcy court, and although it may be based on order of rank, it's not necessarily. But when it comes to liquidation, Chapter 7, there is a distinct order of rank of who gets paid off first from the bankruptcy estate. Secured claims, this is why it's important to have a secured claim, right? Those are going to get paid off first. And we've talked about what secured claims are. They are first priority. Now, when it comes to paying off, say there are 5 secured claims. Those are going to generally get equal among themselves. There may be a rank amongst them, but usually it's not going to go entity 1 gets paid and then what's left over goes to 2, 3, 4, and 5. It's usually they're going to get paid an equal amount. If there's more than enough to pay them off completely, then they're all going to get paid equally. But if there's not enough to pay them all off in the bankruptcy estate, then they're going to get usually paid in a similar amount. So let's assume there is enough to pay off all of the secured claims. We then move to what are called priority claims. So we'll talk a little bit later on about what those priority claims are. An example of that is alimony, right? If you own alimony, those priority claims are going to get paid what's left, right? And then lastly, there are unsecured claims, right? So unsecured, if there's enough to pay off secured claims, there's enough to pay off priority claims, Then whatever's left over will go to pay off the unsecured claims. As you can see, it's important to become a secured claim so you get yourself in a higher priority when it comes to bankruptcy court. Secured claims are collaterals used to pay off the debt. If the collateral is not enough remaining, the balance of the debt is then an unsecured claim, right? So in certain types of secured claims, say for example, it's a truck, and I owe $20,000 on that truck. We sell the truck, and it's only $18,000 is what we can get for it. That $2,000 does not come out of the secured claims. Truck gets sold, and I get the $18,000 for that truck. The $2,000 becomes an unsecured claim. Yep. Priority claims. Alimony. It's the first one on the list that always gets paid. Makes sense. We're going to get the kids taken care of first. Administrative expenses that you may have had, right? Those are going to get paid. Administrative expenses for the bankruptcy, those kind of things. Gap expense, expenses in the ordinary course of business during involuntary petition to order for relief. In other words, if I'm still trying to do business, because we want to keep the assets fresh, whatever it may be, those gap expenses are going to get paid as a priority claim. Payment to employees, they're going to fall in that area as well. Employee benefit plans, right? Consumer deposits, that's where if I'm a business and people have paid into a certain amount of money, those consumer deposits are going to get paid out, right? I owe them money. Taxes, they're going to obviously, government wants its money, so it's a priority for sure. Intoxicating injuries. This is a weird one. Don't know how I got in there, but for whatever reason, think about tort claims regarding alcohol, DUIs. If you have you've won a case in which a tort case, right? Somebody's injured you as a result of an intoxication injury, then you have a priority claim. If not, if it's just a tort claim, right? You were in the store, you were injured, they're paying you off on that injury, but they're paying it off over time. And they owe you that money. That drops to the unsecured claim area. All right, unsecured claims, right? So we had secured claims. We know how those are perfected. We have priority claims, which is established by the bankruptcy code, and then we have unsecured claims. There is no priority. Secured claims that exceed the value of the collateral, we've talked about that. Priority claims that exceed a priority claim limit or end up being unsecured claims. And then, of course, there are just some of those that you believe they owe you money, but you didn't secure your interest in anything. Those fall into this unsecured claim, right? All right. Discharge regarding in bankruptcy court. So when you are discharged, in other words, all of your assets are placed into a Chapter 7 bankruptcy, and the trustee figures out what the bankruptcy estate is, pays off what it can. At that point in time, any debts that you owed previously are now discharged. They can't come after you for those debts at a later point in time because you've started a new business is performing well. Nope. All of those past debts are discharged. That's kind of the beauty of the system, if you will. After termination of bankruptcy, any creditors cannot make a claim against a debtor for any money owed before the petition was filed. Debtors no longer liable to pay any of the debts owed. If they tried to collect on those, they could be sued and they would lose. Here are some exceptions. See those on list? It's quite a bit, so I didn't include them all. They're on page 572. You don't need to know what they are. You're not going to be tested on what they are. They're not going to show up any of the fact patterns on the test. But if you want to take a look, it's on page 572. Some circumstances that can prevent the discharge of those debts. Right. Under Chapter 7, only debts of individuals can be discharged, not organizations. Once assets have been distributed, it must cease all operations. If it doesn't, it can be liable for all pre-petition debts. What that means is if I'm a business, right, and I go to bankruptcy, I file Chapter 7, and so it takes care of everything. If I try to go forward under that company name, then I can basically be sued by these other companies when I start making money, and they can actually come back after me with the debts. I cannot use that company name or whatever. You have to change it to some degree. If a court discovers there has been some fraud, it can say, yep, we're no longer going to have you discharged. We're going to reinstate some of these debts and have you pay some of those. if it happens within a year after bankruptcy is finalized. If you acted in bad faith or were dishonest, the court can also deny any discharges at a later point in time as well. In some circumstances, if there's repeated files for bankruptcies, then the court can say, yeah, we're going to reestablish some of these debts. Do want you to know, debtor cannot receive this time period. You're not going to be tested on that, even though I got it bold there. I can't remember, but I don't think there's any test on the paper, on the test, I should say, about that. Debtors who receive Chapter 3 discharge can get a Chapter 7 discharge. Can't, I should say, get a Chapter 7 discharge for 6 years. All right, you guys get to be the judge here. Someone stole a truck full of iPhones. Samsung found the truck abandoned at a truck stop. Samsung sold the iPhones and the truck for $50,000. The iPhone company eventually found out about the truck and sued Sam for the $50,000 and won. Sam also owed $25,000 in back child support. Sam only had $20,000 to his name at the point in time he was being sued by iPhones. All right, the iPhone company. In this particular situation, ultimately the question is going to be who prevails in this situation, right? You want to sort of get yourself into a priority situation, right? So you have to ask yourself, is the iPhone company, are they a secured, was it a secured transaction, so are they a priority? No, there was no contract between the two, right? So it's an unsecured claim. And in this situation here, we talked about priority claims having priority over unsecured claims. And we know that, sorry, didn't do that. We know that the alimony is a priority claim, so it's going to get paid first. Sorry to skip over that. But that's what happens in that situation. There is the alimony is going to get paid. There's going to get the money first before any money goes to that company. All right, let's continue on with the bankruptcy here. Reaffirmation. So I've got Jim, this is from the movie Cinderella Man. That's Jim Braddock, right, being played by Russell Crowe. This is back in the Depression era. He was given some money from the government. He was always embarrassed about having to take government assistance, but he had to do so to take care of his kids. But he then wins a major fight, and after winning that major fight, he comes back and he tries to pay back the money, and the gal was very confused, and nobody had ever done that before, so she didn't quite know how to handle that situation. But that's what that picture is Jim Braddock from the Cinderella Man. A great book, and as well as a great movie, and a good man. All right, reaffirmation debt. Why I have that picture? There's a debtor can promise to pay a debt even after discharge. In other words, even though under a Chapter 7 discharge, I can say and make a promise you, I'm still going to pay you back that $100 that I owed you, and I could be liable for that $100 debt. May want to avoid losing a collateral, right? Say it's a pawn shop, and so you tell them, I'm still going to pay you back that $100, I promise you, and I don't want to lose the golden flute. May feel guilty and want to repay. That's what Jim Braddock did. It may be a family member. I talked about that father-in-law type of situation, right? And because you may want to stay in that business, so you want to stay in good standing with either your lender or your resources, so you may agree to pay them off at a later time. Keys. No violation of the common law fraud standards. File before the discharge is granted. And include a detailed statement as well as to why. And it has to be approved by the court. That's called a reaffirmation. Now, reaffirmation is an official, going to pay back. There's nothing that says you can't always turn around and pay somebody back anyways, right? Even after the bankruptcy court is done and you make some new money, that you can always get goodwill. All right, let's move on from Chapter 7, which is complete liquidation, to Chapter 11, which is reorganization of a business, right? Chapter 11 and Chapter 13 are very similar. The difference is Chapter 11 is reorganization of a business, and Chapter 13 is a reorganization of an individual. Goal, again, is to resuscitate a business so it can, again, become a viable economic company. And an individual, I should have told you that earlier, an individual can file Chapter 11 as well. There may be times, depending on the amount owed or whatever, that it makes more sense to do a Chapter 11 versus a Chapter 13. The key difference from Chapter 7 is there's no trustee unless the debtor's not doing jobs, right? The debtor in possession acts as the own trustee with two important obligations, right? So I am going to, although there's going to be bankruptcy court that's going to determine how I make payments, it's still going to be my responsibility to see that that all happens, whereas the trustee is the one that's taking care of all that stuff in a Chapter 7. Right. So I agree as my obligations as my own trustee, right, is to continue to run the business in as profitable a manner as I can. I'm agreeing to do that as part of a Chapter 11 reorganization. Develop a reorganization plan to repay the creditors, and they get a chance to take a look at it. Right? There is a creditors committee that's then formed. Right? Any of those folks that are considered a creditor, they become part of this committee that can say yay or nay to the plan that I develop. I don't get to create my own. Right? I have to create one, and the creditors committee takes a look at it. It's usually made up of the largest unsecured creditors. You're like, well, what? Why? Why would it be the largest unsecured creditors? Well, if you think about how the priority situation works, who is going to have the greatest incentive to make sure everything is done right on the priority claims and on the secured transaction claims, right? It's going to be those at the bottom who need to have some assets left over, right? So if you have people at the top, they're just going to make sure they get paid. They don't care. They're priority claims, right? So we can use the unsecured creditors are the ones that make up that committee because they're the ones that have the greatest interest to make sure everything is done because they're at the bottom of the food chain. They're going to oversee the reorganization plan as far as what that plan is and how everybody's going to get paid. The plan of reorganization is in that first 120 days. It can be up to 18 months, but usually the first 120 days. It's the debtor's opportunity to develop that plan, right? That plan that's then going to be presented to that creditors committee. There's a confirmation of the plan as far as that creditors committee. Now, if the court approves, if the creditors committee likes the plan and the court approves the plan, then we'll go forward. Now, here's what the court is looking for. Court approves plan if the majority of each class votes in favor of it and yes votes make up at least 2/3 of the total debt in that class. Right, so each of the classes, whether it's folks involved in the secured, priority, or unsecured, at least 2/3 of those folks in each of those groups making up that creditors committee is going to make a decision there, right? Not the creditors committee, of those group folks are going to have to agree on that particular plan. We'll talk about what happens if they don't. We'll do so now. If they don't, if they can't get 2/3 majority, then the court can cram down a plan. It may be the same plan that the creditor has come up with, or excuse me, not the creditor, but the debtor has come up with. It may be a twist that kind of tweaks to that particular plan, and then they're going to say this is going to be the plan going forward, and the creditors are kind of stuck with that. That's called a cram down. All right, again, I'm blocking part of it, but it'll be on Moodle, kind of how it all works. This is sort of a voluntary petition or involuntary petition is what starts the bankruptcy. And then a plan is produced, right? Now, if that plan, as you see, goes up to the top that is rejected, then there's a cram down that can occur, right? And then a confirmation by the court, and then if everything's paid, discharged. It could also be the plan can be disclosed, voted, and then confirmed by the court, and again, if it's paid off, discharged, and then if it's accepted, right, that's how it kind of works. All right. Chapter 13, consumer reorganization. Again, we had Chapter 7, liquidation, Chapter 11, which was Individual or business reorganization, and Chapter 13 is consumer reorganization. Again, it's to rehabilitate an individual, right, a consumer, to repay a portion of the debt with their future earnings. Have to have future earnings. If not, you don't qualify. Here are the qualifications to have it get a Chapter 13. Debt cannot be too high. See the details in the book as to what that means. Have to have a regular source of income. Of course, if you're not making any money, doesn't look like in the foreseeable future you're going to make any money, you're probably going to have to go through a Chapter 7 liquidation. It starts by only the debtor filing the petition. Here, you can't have an involuntary petition, right? The only way you'd have an involuntary petition is if you have a bunch of creditors, you meet the levels, you would do a Chapter 11 bankruptcy by involuntary means. If it wants to be started by the individual, they can do it voluntarily under Chapter 11 or voluntarily here under Chapter 13. Only them under Chapter 13. A trustee is appointed in this situation here. It's not your responsibility alone. A debtor has to come up with that plan of payment. It's very similar to what we talked about in Chapter 11, but it's got to be approved by that trustee. The debtors must agree to commit future earnings to pay the debts. They have to promise to pay all secured and priority claims in full and treat all unsecured claims equally. So whatever that future earnings are, they're agreeing that there's enough of it to pay off groups in 1 and 2, and then 60 cents, 75 cents equally on a dollar for any of the unsecured claims. If plan does not pay off all creditors in full, then debtor must agree to use any disposable income for the next 5 years to pay down that debt. Within 30 days from filing the plan, debtor starts making payments to the trustee. Even though the plan may not be approved by the court, but it's filed, they then put into, again, it's called bankruptcy estate, money that then will be used later on to pay off as agreed to in whatever that final plan is. If plan is approved, funds then are used to pay the creditors. If plan is rejected, funds can be returned to the debtor. They can be used for Chapter 7 liquidation, whatever it may be, but usually the funds are returned to the debtor. All right, court's general requirements for the plan. Creditors have had right to voice objections to the plan, right? Usually going to want statements back from those folks who are owed money that they're good with the plan. Unsecured claims receive as much as would have under Chapter 7. In other words, if liquidation is the better way of being processed, the folks in the unsecured claims area are going to get less under Chapter 13 than they would have otherwise in a Chapter 7. The court's going to say we're going to go to Chapter 7, they're going to get more money. The plan's feasible, debtor is clearly going to be able to fulfill the plan, and plan does not go beyond 3 years. There is a limit in there to allow it to go to 5. Debtors are acting in good faith to make any and all the payments. All right, discharge. Once approved, debtor no longer liable for any pre-petition debts other than those in the plan. If you didn't get your claim in there at the time, right, then they're only going to be liable for those. Permanent discharge only occurs when the plan is completely fulfilled. If debtor is unable to complete the plan, the court can revive the debts and convert it to a Chapter 7 bankruptcy. Again, there's a schematic, kind of how it all works. Individual petitions, usually 15 days, get to develop a plan of payment. It can be extended longer. And then 30 days, they have to start making payments to the trustee. There is a court review of that plan with the understanding that the creditors have taken a look at the plan. If the plan is approved, you have partial discharged once the payments are done and completely. You have full discharge. If either the court does not approve the plan or you're under a partial discharge and you don't complete your obligations, then it can go down and become a Chapter 7 bankruptcy. That's how Chapter 13 works. All right, you guys give me the judge for this case here, and as you're going to see, this is a fairly short video. I just want to keep these last two shorter than normal because otherwise it was going to be a really long video. And one, I'd struggle with that, and two, you guys would be really bored at that point in time. So Marama versus Citizens Bank was an actual case in there. Robert Marama filed a voluntary petition under Chapter 7. When he filed the petition, he lied about a house in Maine and how that house got into a trust which he was the sole beneficiary of. He listed the value of the house trust as 0. He also lied about the fact that he hadn't transferred any property last year. He had actually transferred the house into that trust. He lied when he said he was not entitled to any tax refunds. He knew he had a $8,700 check in the mail. It didn't take long for trusts to figure out that the house had value and that they were going to attach it as part of the assets to be sold. The proceeds distributed to the creditors, the biggest secured creditor being Citizens Bank. Knowing he was going to lose the house, Marama filed notice to convert his Chapter 7 bankruptcy, liquidation of all assets, to a Chapter 13 bankruptcy, right? A consumer type of bankruptcy. The trustees and the creditors objected. You can transfer from one to another in some certain cases. What do you guys think here? Can Marama switch midstream as a matter of law? Yes, as a matter of law, he can. It does allow, the code allows for you to switch back and forth. Why would he want to switch? Well, he'd want to switch because maybe he really wanted that house. It was a family house, and he didn't want to lose that particular house. Can creditors object to switch? Yes, they can. They can make objections, and it's up to the court to decide whether to agree to have that switch. Why would they object? Because there's more money available for them. They're going to get paid more as a result of now finding that there's $8,700 in a tax refund, and maybe the house has a $100,000 value. Right? Can the bankruptcy court deny the switch? Absolutely, it can. If so, what legal theory should court use to deny? Here, because there was fraud, because there was that he lied, and he was trying to get away with it, acting in bad faith, the court could say, yeah, too bad, so sorry, you have to be honest, and if you're not, and that's essentially what the court did in this particular case. All right, that's the end of this particular video. Again, the last one. Again, thank you all for participating in class, and good luck on test number 4, and have a great summer. Take care.